The Flynn judicial saga literally is the never-ending story, and for anybody who doesn't remember the movie,
what is the secret of the never-ending story?
A lawyer with integrity.
But that's impossible!
Viva Frei, Montreal litigator turned YouTuber, and we have entered into yet another chapter of the Michael Flynn judicial saga, this time Michael Flynn's response to Judge Sullivan's petition for rehearing en banc. Now, for those of you who may not know what is going on in this situation, I'm not giving you a 30,000-foot overview. There is not enough oxygen in my car to do that. I'm going to link a playlist of the Michael Flynn judicial saga right here. Give it a watch if you happen to not know what's going on, but I take for granted most of you do. Judge Emmett Sullivan recently got his tushy spanked by the Court of Appeal in a 2-to-1 split decision where the Court of Appeal granted Michael Flynn's petition for the issuance of a writ of mandamus, ordering Judge Sullivan to grant the Department of Justice's motion to dismiss the charges against Michael Flynn and dismiss Michael Flynn's guilty plea. I did it. I actually did it. I didn't even want to do a 30,000-foot overview. I just did it in one breath. Booyah! And by the way, I've got to do this vlog relatively quickly because we're having something of a block party on our freshly paved street, and I've ducked out of it for a few minutes to go to the car to do a vlog. I told my wife I was going to the bathroom, and
that was 10 minutes ago.
The Court of Appeal, in a 2-to-1 split decision, granted Michael Flynn's petition for the issuance of a writ of mandamus in a scathing decision against Judge Emmett Sullivan. And what does Judge Emmett Sullivan do? Instead of admitting defeat and just doing what the Court of Appeal just told him to do, he filed a petition for rehearing en banc before the entire Court of Appeal. I was not particularly impressed with that petition. I did a video breaking it down. I'll link that video right here if you want to get a feel for what Judge Emmett Sullivan pleaded, but now we have Michael Flynn's response to that petition for rehearing en banc, and it is a very, very well-drafted petition. The best thing to happen to Michael Flynn in the context of this entire judicial saga was getting new counsel, because as of the moment he got new counsel, he has been crushing it. And this response is no different, so let's just jump right into it. In the United States Court of Appeals for the District of Columbia Circuit, in re Michael T. Flynn petitioner, on petition for a writ of mandamus to the United States District Court for the District of Columbia, Michael T. Flynn's opposition to rehearing en banc. No federal circuit has countenanced rehearing of a mandamus on petition by a district judge. And for those of you who may not know what countenance means, it means to admit as acceptable or possible. No federal circuit has admitted as acceptable or possible a rehearing of a mandamus on petition by a district judge. That is one heck of a way to start an opposition brief. Judge Sullivan has no cognizable interest in the case. And for those of you who may not know what cognizable means, it means clearly identifiable or within the jurisdiction of the court. Judge Sullivan has no clearly identifiable interest or interest within the jurisdiction of the court in the case. One heck of a way to start off an opposition brief. Rehearing should be denied because the panel properly applied the long-standing use of mandamus to which General Flynn is clearly entitled, quote, to confine an inferior court to a lawful exercise of its prescribed jurisdiction or to compel it to exercise its authority when it is its duty to do so. Here it is both. Now, a lot of this brief is admittedly repetitive. There are only so many times you can say the same thing. We know the positions of the respective parties. But one of the things I very much appreciate in this brief is that it very quickly rubs Judge Sullivan's face in some of the material facts that were omitted from his petition for rehearing en banc. On May 7, 2020, the government moved to dismiss the information against General Flynn in a significant filing, 20 pages of briefing and 80 pages of new exculpatory documents. These documents and more provide substantial support for the government's determination that there was no crime. General Flynn was, quote, forthcoming with the agents, end quote. And the FBI had ordered the investigation of him closed because even surveillance over multiple months produced no derogatory information. More stunning text messages from Agent Peter Stroke and agent's notes demonstrated the directors of the FBI and others sought to set Flynn up, quote, prosecute, end quote, him, or, quote, get him fired, end quote. The motion recited General Flynn's agreement, and he separately filed notice of consent. Dismissal was required then under this court's ruling in Amadown and Fokker servers. Just a few of these highly material facts were conveniently omitted from Judge Gleason's amicus brief and Judge Sullivan's petition for rehearing en banc. Just a few of them conveniently omitted for reasons that we can only imagine. After highlighting these facts, which really call into question Judge Sullivan's description of the events, they then go on to make a novel argument that no conviction was actually ever entered against Michael Flynn. No judgment of conviction was ever entered against General Flynn. The PFR, which means the petition for rehearing, relies heavily on the novel notion that Judge Sullivan has more authority to scrutinize the decision of the executive branch to dismiss this case because General Flynn had, quote, two separate judgments of conviction, end quote. This is wrong on every level. One, a guilty plea is not a conviction. There is no, quote, conviction until a defendant is sentenced and an appealable judgment is entered. Two, the, quote, plea proceeding, end quote, conducted by Judge Contreras is void. Judge Contreras was recused almost immediately for reasons long known to the government but not to Flynn. Quote, if a judge should have been recused from the proceedings, then any work produced by that judge must also be recused, that is, suppressed, end quote. And for those of you who may not know, the first judge in the file, Judge Contreras, mysteriously recused himself from the file, but it was later disclosed that he did so because he had a rather close relationship to one of the FBI agents involved in the investigation, that being Peter Strzok. Ow. The text messages show that Peter Strzok, a veteran FBI counterintelligence official who until last summer worked on the Flynn case as part of Mueller's team, knew Contreras. The texts also appear to show him musing whether his relationship with Contreras might warrant the judge's recusal. Nothing to see here, people. This is just another day in the judicial system, right? 3. Nor was Judge Contreras' invalid Rule 11 colloquy cured by Judge Sullivan's, quote, extended colloquy. Not only did Judge Sullivan fail to ask core questions, he ended his proceedings stating he had, quote, many questions, end quote, about the factual basis for the plea. General Flynn's guilty plea is thus invalid, and he moved to withdraw it for that and many additional reasons, which Judge Sullivan also ignores. And Judge Sullivan must just be a glutton for punishment because he just keeps getting spanked and he just keeps coming back for more.
Thank you, sir. May I have another?
And as they say, when your case is strong on the facts, bang on the facts. When your case is strong on the law, bang on the law. And when your case is weak on both, bang on the table. Now they are banging yet again on the law and the facts. The government has the right to dismiss at any time, even after sentencing or after certiorari is granted. The bottom line in law being that it doesn't even matter if Michael Flynn did in fact plead guilty and his guilty plea was in fact valid. The government can move to dismiss even after a guilty plea. Flynn's attorneys then go on to raise an interesting new argument, that being that Judge Sullivan has no legal standing to litigate. No rule or precedent authorizes a district judge to seek rehearing of a mandamus order. A district court ordered to respond to a petition for a writ of mandamus is not thereby endowed with the rights of a party. The resulting mandamus from this court to Judge Sullivan, just like any appellate order to a district court, does not give the judge standing to litigate issues, quote, as a party, intervener, or amicus. The irreducible constitutional minimum of standing contains 3 elements, the first of which is an injury in fact that is concrete and particularized and actual and imminent. Judge Sullivan, the supposed umpire, does not make it to first base. He has no injury. And this is an interesting argument in law to the effect that Judge Sullivan does not become a party to the suit because the Court of Appeal tells him to do something. The writ of mandamus that was issued by the Court of Appeal is basically just telling Judge Sullivan to do his job. He is not sustaining an injury. He does not become a party to the suit. He has no legal standing to even petition for rehearing en banc. Or at least that is the argument in law. We'll see what the Court of Appeal has to say. And this warrants an observation. From what I understand, any one of the Court of Appeal's judges could have asked for a rehearing en banc if they thought the question was deserving enough of a rehearing en banc, but no one did it. No one is fighting for Judge Sullivan, and he is the only one left fighting for himself. And Flynn's attorneys are basically saying he has no legal standing to even fight for himself. He's not a party to the suit. He has sustained no injury from the order that was issued. He has no legal standing to do what he is trying to do. Flynn's attorneys then cite a precedent which apparently confirms this principle. The Second Circuit's rejection of Judge Scheinlin's novel effort to get into the game by seeking reconsideration of its order reassigning one of her cases applies with equal force here. We know of no precedent suggesting that a district judge has standing before an appellate court to protest reassignment of a case. Reassignment is not a legal injury to the district judge. Rather, reassignment allows the courts to ensure that cases are decided by judges without even an appearance of partiality. A district judge has no legal interest in a case or its outcome and consequently suffers no legal injury by reassignment. Now recall that the Court of Appeal did not reassign the case from Sullivan, but they could have in their order. They just issued the mandamus without issuing the reassignment, but the argument is that basically what applies to the reassignment applies to the mandamus. Sullivan has no legal interest to ask for what he's asking for. And because Judge Sullivan seems to be a glutton for judicial punishment, Michael Flynn's attorneys oblige. It is Judge Sullivan who is disrupting the, quote, orderly administration of justice, end quote. Not only does the law require him to have granted the government's substantial motion with no fuss, but he should have also granted General Flynn's 2 motions opposing amicus. He had 6 more days to reconsider before General Flynn petitioned for mandamus. Judge Sullivan also should have ordered dismissal promptly upon receipt of the court's opinion. Instead, he waited another 15 days to file an improper petition for rehearing. As Ligon quoted from the Ninth Circuit, quote, in the scheme of the federal judicial system, the district court is required to follow and implement our decisions just as we are oath and duty bound to follow the decisions and mandates of the United States Supreme Court. But for whatever the reason, Judge Sullivan just can't comply. He just cannot give up. Then we go over arguments that have already been made as relates to the requirement for dismissal under the Rule 48A. The panel opinion did not make new law. Every reported decision applying Rule 48A requires the court to grant the government's substantial motion to dismiss. A, quote, hearing, end quote, is warranted only in the rare case where the government government provided nothing more than a bald allegation of, quote, public interest, end quote. No, quote, development of the record, end quote, of any kind is necessary or proper when the government's motion to dismiss is not only fully briefed, but is also heavily documented with 80 pages of exculpatory evidence, all of which the district court ignores along with all Flynn's motions. And now we see the strategic benefit to having mentioned all of that exculpatory evidence earlier on in this brief, all of which was somewhat ignored by Judge Gleeson and by Judge Sullivan in their respective briefs. At all material times, both Gleeson and Sullivan totally mischaracterized the government's position, pretended that no reasons were given for which the dismissal was being sought, when in fact it was highly detailed and highly supported by extremely relevant evidence. General Flynn also has a right not to hemorrhage time and money in a proceeding that is moot because the previously adverse parties are now aligned, or to receive orders from a judge no longer presiding over a live controversy. General Flynn's personal freedom is at stake. He cannot travel freely, obtain employment, or enjoy a normal life until this case is dismissed. His very liberty is wrongly impaired until the dismissal is granted. Forcing General Flynn to continue undergoing such an ultra-virus prosecution in violation of Articles 2 and 3 causes him irreparable harm, and the gravity of the district court's usurpation of power demands a prompt dismissal. And Flynn's attorneys save the best for last. Judge Sullivan's extraordinary actions arise solely from his disagreement with the government's decision to dismiss the case against General Flynn. Not only did he wrongfully tar General Flynn with a baseless assertion of treason, but he has been vocal that General Flynn should be punished severely. Disagreement over a charging decision provides no basis to deny the government's motion. So that is it. Short, sweet, to the point, and in law 19 pages long is short, sweet, and to the point. We will see where this goes. You know, as soon as there is a decision, I will be doing a vlog on it, and I hope when all this is done that Sidney Powell will do a live stream with me on my channel. Please, please, please. That was part of the other reason why I insisted on doing this vlog instead of going to the block party, which I think is actually over because I don't see anybody on the street anymore. Man, with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got merch, PayPal, Subscribestar, Patreon, YouTube membership. But above all else, take care of yourselves, stay safe, stay healthy, get outside, get some fresh air, exercise, and now you know your vlog. Peace out. Booyah!